I'm going to read the motion for summary judgment, and it's about 73 pages. The first 4 or 5 pages are just like the table of contents or whatever, but I've heard it's pretty spicy. But, like usual, I don't see anybody reading it online, so I'm going to read it for you. Let's jump right into it. This is the summary judgment from the Wayfarer side, and we are just going to jump right in where it starts, okay? So if you want to follow along with me, I will put the link down in the show notes and you can follow along. We're already scrolling down to like page 10 or 11 and we don't actually start till page 13. So here's what we've got. Excuse me. Blake Lively, an immensely powerful A-list actor, agreed to act in a film adaptation of It Ends With Us, a book with themes of sex and domestic violence. During the initial stages of filming, she voiced objections to certain on-the-set behavior she did not like. That behavior, involving no more than miscommunications and awkward comments, falls well below the threshold for any claim of sexual harassment or other legal wrong, especially in the context of collaborating to make a sensual and provocative sexually charged film. Regardless, Lively's concerns were heard and fully accommodated. It is disputed that whatever she claimed to have experienced ceased. Filming continued during all future stages, entirely without incident in an environment Lively touted as, quote, perfectly professional and, quote, safe, including the filming of all intimate scenes involving Lively herself. Even Lively's then lawyer said no formal HR process, let alone litigation, was necessary. Any issues have been successfully resolved. Months then went by, but as the film was edited and moved towards its premiere, something else happened. Lively asserted control of the film and took aggressive steps to minimize Justin Baldoni's role, even though Baldoni had conceived, directed, and co-starred in the film, and it had been produced and co-financed by his production company. Wayfarer Studios, Lively took all the credit. Or even though it was co-produced by his production company, Wayfarer Studios, Lively took all the credit. She wrote to the Producers Guild of America, quote, I've produced every moment of this film from pre-production through production into post and into marketing and worldwide release. She explained, quote, so much has changed, the most significant being the cut of the film that was selected to be released is my cut. At the same time, Lively and her actor husband, Ryan Reynolds, disparaged Baldoni to their famous high-profile friends in Hollywood and to Baldoni's talent agency. As the film's premiere approached, Lively became increasingly hostile. She excluded Baldoni from marketing materials, press, and promotions for the film, snubbed him on social media, urged Sony to eliminate his A Film By credit, and even tried to exclude him from the premiere. In light of these astounding developments, and not the minor concerns about the on-set behavior raised and successfully resolved many months earlier, Baldoni sought the advice of a crisis management public relations firm as any responsible person in his position would do. He wanted to minimize the fallout from the media coverage of Blake Lively's increasing attempts to alienate him from the film. He did so for the benefit of both his professional reputation and the newly released film. He relied on media professionals to boost his image and assure that any coverage would be balanced and accurate. None of that is against the law. Aided by two of the world's largest litigation firms, Lively now seeks to create causes of action where none exist. She cannot show the behavior she disliked was caused by her sex or gender, a basic prerequisite for her sexual harassment claims. She alleges Baldoni's resort to public relations professionals was retaliation for complaints she had raised. This ignores the large temporal gap, not to mention the many intervening events between her raising of concerns and Baldoni's resort to crisis management professionals. There can be no claim for retaliation based on purported complaints raised in the distant past, nor did Baldoni and his co-defendants engage in a defamatory smear campaign. It was not illegal for Baldoni to promote positive content about himself or truthful narratives about various events. That Lively's reputation may have suffered is a result of her own ill-advised public statements and actions. This is a dispute about Hollywood reputations, not genuine legal wrongs. It does not belong in court. Justin Baldoni is an actor, director, producer, and author with significant experience in addressing gender issues, including in 2 published books and a podcast devoted to questions about masculinity, all aimed at a predominantly male audience. In 2019, he obtained the rights to produce a film based on Colleen Hoover's best-selling novel It Ends With Us. Baldoni's production company, Wayfarer Studios, which specializes in films designed to promote social change, initiated work on the film alongside Sony, with Baldoni set to serve as the film's director and lead male actor. Because the story focused on issues of domestic violence, Baldoni and Wayfarer partnered with No More, an organization dedicated to ending domestic and sexual violence, and agreed to contribute a portion of the film's proceeds to support survivors of abuse. In early planning, the parties agreed the film's publicity needed to center upon and carefully handle these serious themes. Lively chose to take a lead role in a sexually charged film with adult themes. In December 2022, years into the film's development, Blake Lively, a well-known prominent actor, was cast as the female lead. Lively never read the book. She understood, nevertheless, based on the script and before she accepted the role, that the film would include sexual content and address domestic violence. Prior to filming, we reviewed notes from a female Sony executive stating that the audience was expecting something grown-up and sexy with real heat. Lively worked as an independent contractor, but no contract was ever formed. The parties never executed any contract concerning Lively's role. Negotiations began in December 22 between It Ends With Us Movie LLC, an entity Wayfarer Studios formed to produce the film, and Blakely Incorporated, a loan-out company lending Lively to perform in the film. An offer letter dated March 17, 2023 set forth the basic financial terms, which promised Lively a $1.7 million fee plus various bonuses, but did not contain any terms regarding sexual harassment. The parties also worked towards a separate long-form agreement to include other material terms. IEWUM's obligations under the offer letter were expressly subject to a conditional precedent, namely, quote, full execution of an agreement in the form reasonably acceptable to all parties. IEWM's counsel circulated a draft of the anticipated long-form agreement between IEWUM and Blakely, which is just Blake L. Incorporated. Actors Loan-Out Agreement in May 2023. The draft stated conditions precedent including full execution of the agreement and receipt of an executed document known as an inducement. It also had a merger clause specifying that it constituted the entire agreement between the parties, a provision prohibiting special or consequential damages, and certain other, quote, standard terms, including one stating there would no actionable breach for any conduct unless notice was provided and cure not effected within 30 days. The same or similar terms endured throughout the drafting process. As work proceeded on the film, payments were made pursuant to the offer letter. The parties continued to negotiate the terms of the long-form ALA into July 2024, but Lively herself continued withholding her signature to avoid being bound. No ALA was ever signed. From the outset, Lively sought increased control of the film, which is what she says in her PGA letter as well. Although recruited to act in the film, Lively immediately assumed an active role in production and in developing the film's script, even before filming began. Among other things, she provided Baldoni with a rewrite of the rooftop scene in which Baldoni's character and Lively's characters first meet. She explained that her version of the scene increased the, quote, sexual tension. It retained a line from the book in which Baldoni's character tells Lily, I wanna you. In messages to Baldoni, Lively referred to her revised draft as featuring flirty and yummy ball busting. We remember those texts. We remember the ball busting text, don't we? Also, Colleen Hoover, this supposed to be a young adult novel? Gross. Lively took special steps to convince Baldoni to accept her version of this scene. She asked her friend, the world-famous musician Taylor Swift, to stop by with Baldoni, quote, this doofus director of my movie, and, quote, a clown, would be meeting Lively at her apartment. Lively asked Swift to promote her version of the film, even without having read it. After the meeting, Baldoni told Lively he would have gladly accepted her revisions, even without urging from Swift or Lively's famous actor husband, Ryan Reynolds. Lively has since disclosed that Reynolds, not she, rewrote the scene. This episode, which occurred even before filming began, was the first of a series of events in which Lively relied on an array of Hollywood friends to increase her control over the film while denigrating Baldoni to them along the way. Before filming began, Lively took additional steps to influence the director and to take control of the film. At her request, Wayfarer abandoned plans to film the movie in Boston, where the novel takes place, and relocated the set to New Jersey, near Lively's home. Wayfarer also agreed to change the start date and schedule to accommodate Lively's other professional and personal commitments. Lively raised concerns about her physical appearance. Having recently given birth, Lively expressed concerns to Baldoni and others that she was not in top shape and wanted to look her best for the film. When Lively asked Baldoni to push the, quote, body scenes to the end of the filming schedule, Baldoni responded kindly, quote, I want you to know you will look amazing. Anything you are insecure about, we will talk through and get creative together and make you comfortable. I just don't want you to stress about your body. It's the last thing you need. Meanwhile, Lively raised the same concerns to her agent, noting that she was, quote, working out twice a day, 4 hours a day, because, quote, I want to set us all up for success. Lively's communications reflect her frank awareness that the film was intended to achieve a certain sexualized imagery. She told her agent, quote, this sexiness in this film and the marketing, I'm sure, is critical to its success. Lively was equally frank with Baldoni. Quote, I know my job here. As woke as we both are and work to be, this movie requires a certain aesthetic. It's part of the job that we both excitedly signed up for, she added. I don't shy away from it because it's not problematic. Wayfarer, i.e. WUM, and Baldoni took steps to create a safe set. Wayfarer had a set of industry-standard policies and procedures in place to prevent harassment, discrimination, and retaliation. Its employee handbook expressly prohibits such conduct and encourages employees to report violations. To enforce these procedures, Wayfarer had an HR department with dedicated staff. Prior to filming, WUM held an anti-discrimination training administered by an outside law firm. WUM also included a worker safety hotline on its daily call sheets. Lively benefited from other protections as well. The offer letter provided that she would not perform any nudity-simulated sex without her prior written consent and without negotiation and execution of a formal nudity rider. In April 2023, before filming began, IEWUM hired Elizabeth Talbot to serve as the intimacy coordinator for the film. Lively was given the opportunity to meet with Talbot a month before filming began, but declined. Before shooting began, Talbot considered the content of anticipated intimate scenes and suggested details and clarifications. She also spoke with Lively about Lively's boundaries. When Lively expressed reservations about intimate scenes, Baldoni volunteered to keep the focus on his own body so that the scenes could be choreographed in a way that keeps Blake's clothes on as much as possible. And that's in quote. Choreographed in a way that keeps Blake's clothes on as much as possible. Prior to shooting, Lively and Baldoni were both provided with nudity riders detailing their consent and boundaries concerning intimate scenes. In the first phase of filming, Lively did not film any intimate scenes, but voiced objections to certain behavior. Filming began on the set in New Jersey on May 15, 2023. It stopped on June 14, 2023 due to the Writers Guild of America and SAG-AFTRA. None of Lively's intimate scenes were rehearsed or filmed during this period. However, all the incidents Lively now categorizes as compromising a, quote, hostile work environment occurred prior to or during the first phase of filming. Lively's stated concerns, even if accepted as true, all involve incidents of relatively low-level or innocuous behavior that, considered separately or together, fall far short of actionable discrimination or sexual harassment. For instance, Lively claims Baldoni, quote, described his genitalia in the first meeting before she had agreed to join the film. This is a hyperbolic lawyer spin on what really happened. During the meeting, Lively raised the topic of circumcision. She was pregnant and noted that she and her husband were considering the issue because they were expecting a son. Baldoni responded by noting that he appreciated the issue and that he and his wife had grappled with the same question for their children because his parents had chose to circumcise him. Such a statement is obviously not justification to bring any claim to court. Indeed, Lively herself seemed unfazed. She had raised the subject, did not complain to anyone at the time, and after the meeting, her husband sent Baldoni an effusive message saying both he and Lively were big fans, quote, of his. Lively also accuses Baldoni of fat-shaming. The allegation is based on a single instance in which Baldoni, who had chronic back problems and anticipated a scene in which he would have to lift Lively up, privately asked a physical trainer he had consulted with, who also trained Lively, about her weight. He did so discreetly, outside the workplace and outside Lively's hearing. But even if this inquiry was, as Lively now portrays it, a sly criticism, any petty slight that might have arisen within when the trainer or his own initiative repeated the comment to Lively is simply too trivial to constitute sexual harassment. Lively further accuses Baldoni of adding a gratuitous sexual content to the script before filming began. The evidence shows, however, that the scenes were added with the encouragement of a female Sony executive to align with the explicit female-authored book on which the film was based. Baldoni asked a female intimacy courter to review them with Lively. To the extent Lively objected, scenes were revised or removed. Moreover, Lively herself rewrote other scenes to boost their sexual vibe. Lively claims Baldoni improperly used the word sexy to refer to her wardrobe on one occasion and to that of another actor on another occasion, and that at one point he complimented Lively's own personal low-cut outfit. Such passing, sporadic comments, while perhaps ill-advised, are not outrageously offensive in an environment where professionals are working closely to make a deliberately sexually charged film. Lively also asserts that Baldoni at times alluded to his own sexual and marital experiences. Again, such experiences are hardly surprising given that Lively and Baldoni were collaborating and communicating daily about how to best portray various adult and marital themes. Lively also claims Jamie Heath, Wayfarer's CEO and one of the film's producers, momentarily glanced at her naked upper body after she permitted him to come into her trailer while she was having body makeup removed. Lively says she instructed Heath not to look at her, but at some point during their brief conversation, he glanced at her through the mirror. Whatever fleeting mishap may or may not have occurred, it is being characterized as sinister only in retrospect. At the time, Lively said, "I know you weren't trying to cop a look." That's her direct quote. Lively also objected to being shown a video image relating to Heath's wife's home birth, incorrectly believing it was pornography. A female Sony executive testified that Lively expressed displeasure to her. The executive reviewed the same image and concluded that there was no need to take any further action because Lively's reaction was a result of a misunderstanding or a mistake. The film includes an important scene between Lively and Baldoni's characters surrounding the birth of their child, and Baldoni and Lively had discussed the scene before Heath shared the video image. Lively includes an assortment of other objects in her complaint, including that she contracted COVID on set, that after Lively told Baldoni she had never seen pornography, he shared the fact with others, that at one point Baldoni shared a personal story about being pushed past his own consent boundaries, an experience he has discussed publicly, including in his published books, and that there was too much hugging on set. Lively's objections were addressed before and during the filming hiatus. Although Lively's description of events is disputed, what is undisputed is that Lively's objections were resolved as soon as they were raised. Lively chose not to file any formal complaint. Instead, as she told another cast member at the time, she preferred to, quote, personally tackle them. Consistent with that approach, after Lively and her husband chastised Baldoni for inquiring about her weight, the issue did not recur. Lively objected to certain sex scenes, and Baldoni revised or eliminated them accordingly. On June 1st, 2023, a few weeks into shooting, Lively met with Baldoni and Heath and reviewed various matters she was unhappy about. Baldoni and Heath apologized for Lively's discomfort. Evidently, that was enough to resolve the issue. Lively had not identified any incident after that meeting that she claims constitutes sexual harassment. On November 9th, 2023, 5 months after filming had stopped due to the strikes, Lively, through her entertainment lawyer, sent a list of protections she wanted observed in connection with any future filming. Lively's lawyer said a signed agreement to abide by the protections would suffice in lieu of a more formal HR process. Lively did not commence any litigation or file any formal complaint, though her lawyer noted she reserved all legal rights. The requested protections largely replicated protections that were already in place, such as the use of nudity writers and an intimacy coordinator. Other protections implicated conduct Lively had herself engaged in during the earlier phases of filming, such as improvising kissing in scenes, commenting on her own physical appearance and that of others, and hugging other cast members. On January 4th, Lively held a production meeting at her apartment. Lively and her husband hijacked the proceedings to berate Baldoni and Heath for their purported behavior months before. Lively read a list of grievances from her phone that included, in addition to incidents discussed above, a demand that Baldoni not speak to her dead father, mention his own religious beliefs, or have, quote, private multi-hour meetings in Lively's trailer with Mr. Baldoni crying. Lively also demanded notice of COVID exposures on set. On or about January 19th, 2024, Heath, acting on behalf of IEWUM, signed the protections as incorporated into a rider to the unsigned ALA between IEWUM and Blakel Incorporated. Lively refers to this document as the Contract Rider Agreement. The CRA does not include any admissions of improper conduct. It is a forward-looking document concerning behaviors once filming resumes. All right, we're 20 minutes into this, and it's pretty detailed already. Go ahead and make sure you're staying hydrated. I've got my coffee and my water, so make sure that you are drinking as well. We're on page 23 at the H headline. The second phase of filming proceeded without incident. Filming resumed on January 5th, 2024, and concluded February 9th. Lively raised no further objections and told another female cast the set was, quote, professional. Whatever issues had been raised months before, had been fully resolved. Lively used her famous friends and connections to take control of the film. Shortly after filming wrapped, Lively told Sony she would not agree to promote the film unless she was permitted to participate in the edit. Thereafter, she amassed an enormous level of control over the film. While Lively received pushback, she recruited famous friends including Matt and Lucy Damon, Ben Affleck, and Taylor Swift to support her, while disparaging Baldoni to them as a chaotic clown. Lively connived with Swift to use the rights to Swift's music to gain leverage over the trailer. Swift told Lively using her music, quote, gives you more power over the film. That's your allies, not Baldoni's. Lively agreed it was, quote, stupid for Baldoni to use the song because it cost him, quote, his only shot at having the appearance of the upper hand. When Baldoni, the film's director, produced a cut of the film that scored higher with test audiences than Lively's, she still pushed the studio to reject it, writing, quote, Colleen Hoover and I are declaring now, this is the cut. It's done from my perspective, from Colleen and from Taylor Swift's, and from Sony's. Lively also insisted on changes to the film credits, including moving her own name up on the list of producers and removing Baldoni's film by credit altogether. In a June 25, 2024 letter to the Producers Guild of America, Lively described what she claims was an extraordinary role in bringing almost every aspect of the film from start to finish. Quote, I've produced every moment of this film from pre-production through production into post and now into marketing and worldwide release. She explains, quote, so much changed, the most significant being the cut of the film that was selected to be released is my cut. Her long letter is not shy about listing numerous claimed accomplishments. It's a remarkable document. She takes credit for, among other things, determining the location of the film, putting forth the name of the department heads, reshaping, quote, the creative of the production design for all key locations and characters, reshaping the, quote, creative and costume designs for all characters, significant rewrites of the script, quote, firing the first assistant director, helping to, quote, block the staging of every scene, calling and leading meetings with all department heads, the studio and distributor, and re-editing the film. Lively also asserted that she was heavily involved in developing the film's marketing strategy, a claim backed by a Sony executive. Lively stirred up negative press about Baldoni and the film. Apparently not content to have wrestled directorial and editorial control from Baldoni, Lively set out to destroy his reputation and alienate him from his own film. Lively and her famous husband unfollowed Baldoni on social media, encouraging the press and fans to suspect a feud. Reynolds told their famous Hollywood friends that Baldoni belonged in jail. He told the executive chairman of WME, the powerful talent agency, that Baldoni was, quote, a thoroughbred predator fraudster. Lively told Hoover and another prominent author that Baldoni was a narcissist. Even Anna Wintour of Vogue magazine heard about how hard the production had been for Lively. Lively also took steps to exclude Baldoni from all press associated with the film, including a high-profile event at Hoover's Romance Book Convention. Unsurprisingly, the press took notice. Lively and Hoover discussed a post from a prominent gossip blog observing Baldoni's outcast status, but Lively wanted more. On July 22nd, she told Sony she would not attend the film's upcoming premiere if Baldoni, the film's creator, director, and male lead, was also there. Ultimately, Baldoni was allowed to attend, so long as he left the red carpet before Lively arrived. waited in the basement while she and her famous friends were photographed, and then watched the film in a separate theater. Baldoni and Wayfarer then hired a crisis management team. It was in this context, in late July 2024, over a year after Lively's concerns about the on-set behavior had been fully resolved, and faced with a new set of concerns relating to media coverage surrounding the following of the film's premiere, that Baldoni and Wayfarer first entertained the concept of hiring a crisis PR team. Even as the negative press intensified, Baldoni's team, led by Heath and his longtime publicist Jen Abel of Jones Works, agreed that it would be a mistake to fan the flames and that we should not be doing anything proactive. On July 25th, Baldoni and Heath met with the agency group, Melissa Nathan's PR firm, to discuss retaining the firm for crisis management. In subsequent messages, Wayfarer reiterated that it did not want to take any offensive steps and that Nathan would not be, quote, have any comms outside of the internal teams. On August 2nd, 2024, circulated the scenario planning document that had been the subject of much of Lively's ire. As the title suggests, the document simply laid out a menu of possible options. It was not an agreed upon plan of action. Immediately after the premiere, numerous outlets published stories about the feud between Lively and Baldoni. This was, in part, prompted by Lively's PR representative who told press contacts, quote, the whole cast isn't speaking with Baldoni, and that Lively and Baldoni watched the premiere from separate screening rooms. Baldoni's PR team, led by Abel, Nathan, and Tag, distributed positive information and stories about Baldoni and worked to mitigate the minimize negative ones, standard operating procedure for PR professionals. Baldoni himself made numerous positive public statements about Lively. On August 7th, Abel told Nathan she was still waiting on a, quote, green light from Heath to, quote, put the social combat plan into motion. On August 9th, Wayfarer engaged street relations Jed Wallace's firm to monitor social media concerning Lively, Baldoni, and the film. Contrary to Lively's claims, Wallace testified his firm did not spread negative information about Lively and had no ability to do so. At the same time, Baldoni's team negotiated what they believed was a truce with Lively's PR team, in which neither party would engage with any media, hoping to avoid any adverse publicity that could interfere with the reception of the newly released film. Lively suffered backlash. The attention commanded by Lively's star power and by news of the purported feud was a double-edged sword. By virtue of all the coverage, she was put under a very public microscope. In August 2024, she experienced a massive outpouring of negative sentiment, but the undisputed evidence shows Lively's own missteps were a significant driver of that response. Several press outlets picked up, for example, on Lively's decision to cross-promote a serious film about domestic violence with, among other things, her husband's summer superhero blockbuster, as well as her own hair care and beverage products. Lively privately acknowledged the marketing misstep. Days after the premiere, she reached out to another cast member and advised, we are looking to post resources for people experiencing DV. Sony executives observed the negative publicity had been driven by Lively's own ill-advised promotional strategies. Lively also came under fire for past missteps, including her decision to get married on a former slave plantation, old allegations that she was difficult to work with, and an interview in which she mockingly referred to her infertile interviewer as pregnant, the Little Bump interview. Lively does not dispute that any of these events actually occurred. She merely insinuates that the defendants had a role in bringing them to light. The evidence does not support the headline claims. After months of scorched earth discovery, backed up by a pounding drumbeat of almost daily motions to compel, Lively has been unable to identify any instance in which any defendant distributed or promoted any false story about her, even after subpoenaing dozens of content creators. Her interrogatory response summarizing the evidence of what she described as highly orchestrated smear campaign reveals a surprising truth. What Lively primarily objects to is Baldoni's effort to defend himself, whether by promoting positive stories or trying to suppress negative ones. But that is not retaliation. Instead, Lively's own PR representatives took steps to kill negative stories about Lively, including stories she knew were true during the time period. Even when certain defendants contacted the press about Lively in August 2024, their efforts were far from the sophisticated internet takedown Lively touted in the press. The few instances in which the evidence suggests any defendant spoke to the press about Lively all involved truthful references to her actual conduct or that of her husband, or the sharing of opinions about that conduct. Lively's own PR representative confirmed that such communications are standard fare. In defending her own efforts to share negative information about Baldoni, Lively's representative testified that it is okay to tell a reporter to include negative statements about someone if someone else in the press has already. Once media goes in, they go in. You do not do any of these. We did not do any of these. This is all organic. That's a quote. Baldoni later discussed with Nathan that he had no intention to make Lively an outcast and was praying for her and her family. Lively and Reynolds smeared Baldoni once again. Ironically, Lively's cry that Baldoni tried to bury her more accurately describes her own efforts to tar him. Beginning on August 9, 2024, just one day after Lively alleges the smear campaign began, Reynolds told his agent Lively's PR representative should, quote, fight back in any way necessary. 4 days later, Reynolds described Baldoni as, quote, his shitbag partner, presumably Heath, as, quote, predators and frauds, to WME Executive Chairman Patrick Whitesell. Whitesell reassured Reynolds that WME, quote, won't rest until, quote, all the studio's important buyers know the truth about all of it. Lively's PR rep, in turn, told one reporter Baldoni was a, quote, animal, and told another, quote, you forgot to link the fat-shaming and inappropriate kissing allegations. Lively then used a sham litigation to obtain the private messages of Baldoni's publicist Jen Abel using a shell company as a bogus plaintiff. This company filed claims against 10 anonymous Doe defendants, and working behind the scenes with Abel's former employer, Stephanie Jones, invoked a New York State court subpoena power to obtain Wayfarer's confidential records from Abel's personal phone that Lively would have not otherwise been legally permitted to obtain. That's the Van Sham lawsuit. On December 21st, 2024, the New York Times published a 4,000-word article entitled, We Can Bury Anyone, Inside a Hollywood Smear Machine, that relied on the documents Lively had obtained through the sham lawsuits, as well as an administrative complaint she filed the day prior. The article asserted Baldoni and Heath had violated Lively's physical boundaries and made sexual and other inappropriate comments to her, and then instituted a retaliatory smear campaign. Weeks before the article came out, Taylor Swift gloated to Lively, quote, I think this bitch knows something is coming because he's gotten out his tiny violin. Around the same time, Lively conveniently dropped her New York State court lawsuit, confirming it was not filed in good faith and had only been used as a ploy. Lively initiated the litigation. In December 2024, 18 months after the minor issues she raised about the on-set behavior were fully and successfully resolved, Lively launched this dispute with the administrative complaint and the fanfare of her New York Times headline. The behavior she previously regarded as not requiring any formal HR process was now presented by two large, sophisticated global law firms as sexual harassment of the gravest kind. And Baldoni's natural defense effort after being sidelined from his own premiere to manage his own and his film's reputation by employing experienced PR professionals was now recast as retaliation against Lively for raising purported sexual harassment concerns. Lively's numerous claims against numerous defendants cannot withstand scrutiny. Judgment should be entered for defendants on all claims. For the reasons set forth below, Lively's claims all fail. This motion also incorporates the arguments in the defendant's motion for judgment on the pleadings, including that extraterritorial application of California statutes is improper because, as the undisputed facts show, no alleged instance of harassment took place there. First, Lively cannot prove any actionable sexual harassment. This court, as well as many others, have pointedly observed that in evaluating what constitutes actionable harassment or a hostile work environment, context matters. Comments made on the set of filming a movie about adult themes may have a different material effect from similar comments made in a routine office setting. Lively knowingly took on a lead role in a provocative, sexually charged film based on a book famous for its intense, intimate scenes. When viewed in context, no reasonable juror could find that a handful of comments and miscommunications Lively has mustered amounts to sexual harassment. Lively cannot prove severe or pervasive harassment. The litany of minor grievances Lively cobbles together falls far short of the requisite level of being severe or pervasive enough to create objective, hostile, or abusive work environment. Isolated acts, unless very serious, do not meet the threshold of severity or pervasiveness. The sporadic use of abusive language, gender-related jokes, or occasional teasing are not actionable harassment. In separating low-level objections from legally cognizable wrongs, courts consider the totality of the circumstances, the frequency of the discriminatory conduct, its severity, whether it's physically threatening or humiliating, or a more offensive utterance, and whether it unreasonably interferes with an employee's work performance. It is not enough for Lively to say that she personally found something Baldoni or Heath did objectionable. Both an objective and a subject standard must be met to sustain a claim. Lively's claims, presumed on a few purportedly, quote, offensive utterances, on-set mishaps, do not satisfy these standards. That Baldoni, in directing particular scenes, twice used the adjective sexy to refer to how female actors appeared in their assigned wardrobe is hardly surprising given the sexually charged nature of the scenes in the film. The banality of such conduct and its general low-level offensive is underscored by Lively's own use of the term sexy during her work on the film, and Sony directors to turn up the, quote, heat. Video footage confirms that Baldoni use of the word sexy in reference to Lively's wardrobe was entirely unremarkable. Lively was not scantily clad, but dressed in an oversized fleece onesie. Nor was this anything that might remotely approach flirtation. Rather, both she and Baldoni were working at the time, surrounded by actors and crew. Baldoni's expression was neutral and not ogling or suggestive. On top of that, Baldoni apologized if the remark was inappropriate, and Lively responded by saying, all good. We're getting through this pretty good. We're on page 33. Even in routine office settings, such conduct is not actionable. For example, the Second Circuit held a high school teacher's claims that her male supervisor, quote, occasionally commented on her physical appearance, and, quote, participated in a bet with 3 other male employees as to when he would be able to engage her sexually explicit conversation, were sufficient. Similarly, claims that a senior employee told plaintiff that her clothes were sexy and that her hair was beautiful, sometimes blew a kiss at plaintiff as he did to all his employees, once sent plaintiff an inappropriate email and made sexual jokes were insufficient. Likewise, a file clerk's claims that her supervisor commented her hair and eyes, commented that she looked good in tight pants, and referred to her as a bitch twice were insufficient. Lively's other complaints are equally deficient when viewed in context. It would be one thing if Lively and Baldoni were 2 insurance executives reviewing actuarial figures on a spreadsheet, and out of nowhere, Baldoni alluded to his marital or sexual experiences or to a prior pornographic addiction. It is quite another thing here, because Lively and Baldoni were discussing these issues in the context of creating intimate scenes and adult themes in the film they were working on. Lively always had complete control in approving any additions to the script concerning intimacy, as well as access to a female intimacy coordinator, and she raised concerns throughout the entire period in which the movie's most intimate scenes were filmed. Lively's complaint that Baldoni inquired about her weight similarly falls short. He didn't make the comment in the workplace or in the presence of any cast or crew members or even Lively herself. It had no effect on the workplace environment. Someone else communicated to Lively, not at Baldoni's request, and independent of any activity related to the film. But sexual comments did not amount to verbal abuse or harassment inasmuch as the subjects were not even present to hear the speaker's offensive remarks or apparently had no awareness of what had been said. In McSweeney, this court rejected Title VII claims. It observed that calling someone a, quote, housewife or commenting on a coworker's breast implants would be highly offensive in a run-of-the-mill office. At the same time, however, in connection with the reality show Real Housewives of New York City, those comments had a different ring. This court held that even such, quote, obnoxious and insensitive comments do not rise to the level of a petty slight. Do not rise above the level of a petty slight. The California Supreme Court had similarly observed, quote, the circumstance that this was a creative workspace focused on generating scripts for an adult-oriented comedy show features sexual themes is significant in assessing whether the plaintiff had viable harassment claims. The plaintiff's claims that male writers made, quote, graphic comments about having sex with the actress on the show only once or at least twice in 4 months was not sufficient to support her claim that hostility towards women permeated the workplace. Lively's claims suffer from the same fatal defect. Lively was not targeted on the basis of her gender. To sustain a sexual harassment claim, Lively must show that the offending conduct was motivated by her gender and that she was treated a certain way because she was a woman. The critical issue Title VII texts indicate is whether members of one sex are exposed to disadvantageous terms or conditions of employment to which members of the other sex are not exposed. Lively cannot show that here. The basis of many of her claims has nothing to do with her sex. For instance, Lively contends there was too much hugging on the set. She does not claim, let alone prove, that hugging was gender specific. The undisputed evidence, including video footage, shows both men and women being hugged. Perhaps there was a general overgenerosity of spirit among people on the set, but such facially sex-neutral incidents, even if they made Lively subjectively uncomfortable, do not create an environment that a reasonable person would find hostile or abusive. Baldoni spoke with Lively about topics like sexuality, consent, pornography, not motivated by her gender, but because she was his co-lead and collaborator in a film exploring adult themes. It is undisputed that Baldoni has spoken openly about such topics to large audiences of men as well as women, including in 2 published books and a frequent broadcast podcast. No evidence suggests he singled out anyone for differential treatment on the basis of gender. Moreover, it is disputed that the female cast and crew members, including Lively herself, commented on the appearance of both male and female actors and celebrities, while the female executive Sony assigned to the film encouraged Baldoni to include as much tasteful hot sex as you can. Meanwhile, Lively advocated making her own wardrobe, quote, sexier. She explained to male crew members that her boots were so sexy. She oversaw a scene in which there was an unscripted kiss, including her character kissing Baldoni. Against the backdrop of a film devoted to achieving a certain sexy aesthetic, a project Lively embraced and advanced, it is impossible to see occasional sporadic references to sexuality as specifically directed towards either gender. Nor do the 2 alleged instances involving Heath reflect any gender motivation or animus. Lively was shown a fragment of a video depicting family members and a newborn child not because she was a woman, but because she had acted in an important birth-related scene in the film, the details of which she had been discussing with Baldoni. Heath had shown the same video to Baldoni, a man. Similarly, Lively asserts Heath inappropriately glanced at her after being invited into her makeup trailer while she was in a state of undress. Even crediting her account, there is no evidence Heath entered her trailer or did anything else for some untoward sexual reason. He came into her trailer on the second day. Before this dispute arose, Lively herself dismissed that idea, telling Heath, quote, I know you weren't trying to cop a look. Lively relies on the fallacious assumption that any unwelcome reference to sex or sexuality is gender discrimination. That is not the law. Exposure to overtly sexual content, far more egregious than that alleged here, is not actionable if not specifically motivated by gender. In Brown v. Henderson, the court granted summary judgment, and the second court affirmed even where plaintiff alleged she was the butt of jokes about an affair with a male employee, her co-employees threatened to, I don't think I can say this word, I'm going to say it in gibberish, so the god of the gun with the guys, one another, and someone posted a pornographic picture of a naked, obese, spaghetti the geegle with a gun with the gun with the gas to the gerb with the gay to the game. It was undisputed that plaintiff was subject to welcome verbal conduct of sexual nature, but the court rightly found that failure to adduce evidence that the conduct at issue was based on her sex is fatal to her claim. Dismissing claims by plaintiff bartender exposed to private sex parties and nudity, prostitution, and people performing sexual acts in her presence, because plaintiff does not claim that she was subjected to these sites because she is a woman. Lyle is particularly on point. There, the California Supreme Court reinstated a grant of summary judgment dismissing FEHA hostile work environment claims where a female writer for the TV show Friends presented evidence that male writers for the show had engaged in sexual antics, including their pantomiming of Madagascar the Gerb the Geishagan, graphic discussions about their personal sexual experiences, preferences in women, bragging about their personal exploits. Considering the context in which the conduct occurred, the writer's room, for an adult comedy show, the court concluded there was no triable issue that the, quote, writers engaged in harassment because of sex. It found that both men and women engaged in sexual jokes and commentary with no indication such conduct Such conducted was undertaken to, quote, make plaintiff uncomfortable or self-conscious because she was a woman. Defendants completely remediated any alleged offensive behavior. Lively is also unable to show pervasive harassment because any concerns she raised, whether justified or not, were promptly addressed and rectified. Indeed, when filming resumed after Lively had raised a set of requests or protections, it proceeded without issue or incident. A reasonable employee would hardly be able to find their workplace to be pervasively discriminatory if the employer actively took successful steps to protect them from abuse. No harassment where plaintiff offered no facts showing any complaint she made was ignored. Lively does not claim there was any misstep or misdeed by anyone on set after her June 1st, 2023 meeting with Heath and Baldoni. Indeed, before Lively unleashed her battery of high-powered law firms, she herself repeatedly took credit for creating a, quote, perfectly professional and sterile and lovely set. Her agent visited the set and observed that Lively, quote, was feeling very positive about the final phase of the movie, a sentiment echoed by other executives involved in the film who had been privy to Lively's earlier concerns. It is difficult to see how such relatively minor alleged transgressions, all indisputably nipped in the bud while production continued, can support the massive litigation Lively has brought here. Indeed, that is precisely why one of Lively's co-stars, Jenny Slate, declined Lively's invitation to join the suit. As Slate testified, quote, I felt that I settled my issues on set, and I wanted to move on. Lively cannot prove any actionable retaliation. Lively did not experience any actionable adverse action. To sustain a retaliation claim, Lively must prove, among other things, that she suffered an adverse action. Under Title VII, an adverse action must include conduct that would dissuade a reasonable worker from making or supporting a charge of discrimination. I'm just reading the footnote real quick. It says, to create an appearance of ongoing misconduct, Lively alleges the harassment had continued in the form of a coordinated campaign to cast Miss Lively in a false light. That is, at best, a retaliation claim, not a sexual harassment claim. Lively fails to show that the so-called smear campaign was based on her gender, nor would such a campaign constitute an adverse employment action, a term that is defined more narrowly under substantive Title VII law rather than retaliation claims. They require the adverse action be employment-related, that is, it must, quote, materially affect the terms, conditions, or privilege of employment. Sorry, there's a leaf blower outside if that is bothering you. I can't do anything about it, I'm really sorry. Lively did not suffer any employment-related adverse action. No aspect of Lively's employment changed for the worse after she presented her list of requested protections. She was not demoted, sidelined, or paid less. To the contrary, her power in the workplace and control over the production both expanded dramatically. By her own account, also conveyed in the self-congratulatory detail to the PGA, she, quote, rewrote the script and directed every actor and edited and secured the release of her own cut of the film. By her own account, also conveyed in the self-congratulatory detail to the PGA, she, quote, rewrote the script, directed every director, and edited and secured the release of her own cut of the film. No reasonable juror could find that Lively suffered an adverse employment action in any traditional sense. Rather than retaliate against her, defendants acceded to her every demand, providing her with a career boon that she presented as grounds for a prestigious PGA recognition, a first in her career. The only proven publicity efforts were reasonable defensive measures. In lieu of a traditional adverse action, Lively claims that the retaliation against her took the form of a barrage of negative publicity, outside of the workplace and after all of her on-set work was done. Nothing defendants did can fairly be described as retaliation for Lively's engagement in any protected activity. Instead, Baldoni and Wayfarer were reasonably attempting to protect themselves in response to an onslaught of vicious negative publicity launched by Lively and her famous husband. Defendants were exercising First Amendment and due process rights, not stepping on Lively's earlier exercised right to voice concerns in the workplace, which they had honored in full. Even if defendants' conduct in late 2024 somehow could stretch back to workplace concerns raised over a year before, there would still be no actionable harassment. This court knows well that parties accused of harassment are permitted to defend themselves. Then they're down a bunch of case law. The Second Circuit has recognized that such reasonable defensive measures do not violate the anti-retaliation provision of Title VII. Defendants publicly Defendants' publicity efforts, even if construed in their worst possible light, are precisely the type of reasonable defensive measures outside the scope of actionable retaliation. It neither against the law nor retaliatory for Baldoni to put out positive press about himself or attempt to mitigate or suppress any negative stories that may arise. That is classic PR activity. Nor is pointing journalists to pre-existing negative coverage of Lively actionable. And then the footnote says, for the same reason, defendants' lawsuit against Lively cannot support her retaliation claims. As the court recently held, to protect the employer's due process, the First Amendment rights, an employer's counterclaim cannot be deemed an adverse action if it was filed without a retaliatory motive and with reasonable basis in fact or law. The defendants' claims were dismissed based on various previous or other pleading issues is not tantamount to finding that they were filed in bad faith. In Hughes versus 20th Century Fox, the defendant employer was accused of leaking a false narrative to the National Enquirer about the plaintiff's affair with her boss to preempt any actions the plaintiff would have taken to expose her claims that her boss were the gape trigger, as well as the discrimination and blacklisting that she suffered. Even in that ugly context, the court dismissed the retaliation claims, holding that any contact with the National Enquirer was not an adverse action under the anti-discrimination laws, but rather a colorable defense to protect the defendant's business in the face of the plaintiff's inflammatory allegations. The court held such actions were, quote, reasonable defensive measures. The court held such actions were reasonable defensive measures that cannot support a claim for retaliation because none of the emails released are alleged to have been doctored or fabricated. Indeed, it is likely that these emails would become public if the action proceeded to trial. Here, Lively has been unable to identify any instance in which any defendant provided false information about Lively to any member of the press or to any social media influencer. Lively has never asserted defamation claims against Abel, Nathan Tagg, or any other member of the Wayfarer's PR team. Her defamation claims against Wayfarer, Heath, and Baldoni conspicuously fail to identify any statements made in August 2024 when the alleged smear campaign was supposedly in full swing. Lively's digital expert, or quote, inauthentic online activity, Aaron Kulata, similarly fails to identify any false statement about Lively that was supposedly inauthentically amplified. Instead, he focuses on comments where posters criticize Lively on the basis of her own irrefutable conduct, her acting, her demeanor in interviews, her decision to have her husband revise the script, her decision to cross-promote a film about domestic violence with her husband's action-adventure movie, or her alcoholic beverage company, and her decision to unfollow Baldoni on social media. Such posts are not false by any measure. Kulata also observes a resurgence of attention to the Little Bump interview. No one has disputed, however, that the interview actually occurred. The footnote at the bottom of page 29 says, Lively also claimed defendants engaged in sophisticated digital warfare against her. Although Lively will no doubt assert the facts are contested, discovery establishes that digital warfare never happened. In August 2024, long before this dispute, Baldoni repeatedly asked his PR team if they were using bots or fake accounts to foment negative sentiments against Lively, and they assured him they were not. The Second Circuit emphasizes that context matters while assessing retaliation claims just as it does for substantive harassment claims, and a plaintiff's own behavior in the face of a purported retaliation has to be considered. Lee indisputably started the publicity fight, and her reaction to even the hint of any defensive response showed she remained an eager participant on that battlefield. As early as August 9, 2024, virtually the same day Lively claims the purported smear campaign began, Lively and her husband told their PR professional, quote, to engage the studio and fight back in any way necessary. 4 days later, on August 13th, Reynolds pressed the executive chairman of WME, the talent agency representing Reynolds, Lively, and Baldoni, to advocate for Lively. Lively and her team filed a bogus lawsuit in the New York State Court and then subsequently worked with the New York Times to publish a 4,000-word article about Baldoni's purported misconduct based on numerous private and cherry-picked texts improperly seized from Jen Abel's phone. This aggressive response itself shows the media activity transcended not only the workplace, but the bounds of a workplace anti-discrimination laws. I want to take a break real quick and just pause because in the Taylor Swift text messages, she says, "Is everything still on track?" And she says, and Blake responds and says, yes, but like a week later. What I'm picking up is that Taylor Swift is the one who told them how to file the fake lawsuit to get the illegally obtained information from the phone. Okay. Lively cannot prove any protected activity was the but for cause of the alleged smear campaign. Let's go ahead and take a drink of our coffee and our water because we are an hour in. We're about halfway through. We're on page 43. There's only 73 pages, so we're doing pretty good. All right. Lively's retaliation claims also fail for the separate and independent reason that she cannot prove any temporal or casual proximity between defendants' alleged publicity efforts and the list of protections she presented many months before. To establish a causal link between her protected activity and defendants' alleged adverse action, Lively must prove the retaliation was a but-for cause of the employer's adverse action. It is not enough that retaliation was a substantial or motivating factor in the employee's decision. Rather, Lively must prove that the negative publicity campaign would not have happened absent a desire to retaliate against her for her complaints. She cannot do so here. There is no temporal proximity between any claimed protected activity and any alleged adverse action. It is undisputed that Lively faced no real consequences for at least 8 months after presenting her protections demands. On the contrary, filming resumed, including filming of all of Lively's intimate scenes without incident, and she alleges no act of retaliation during the subsequent months of editing. The long temporal gap between her protected activity and an alleged instance of retaliation alone defeats her claims. The footnote says, Lively claimed during her deposition that Baldoni retaliated against her by privately criticizing her to Hoover and Fisher and complaining about her to a film editor. Neither of these events resulted in any material harm to Lively or the conditions of her employment. Moreover, around the same time, Lively told Hoover Baldoni was a narcissist. In any event, Lively didn't raise those incidents in her administrative complaint and thus failed to exhaust her administrative remedies. Oh my goodness. Okay. Lively cannot prove proximate cause. Significant intervening events between Lively's claimed protected activity and the alleged smear campaign also destroy any inference of causation, especially the but-for causation required here. It is ridiculous to suggest that but for Lively's airing of protections some 8 months earlier, defendants would not have hired PR professionals to help manage their reputation. Defendants would have reacted to Lively's onslaught of negative press against them even if no concerns about their on-set behavior had been raised. They had a legitimate interest in protecting their reputations, and the reception of their film after Lively isolated Baldoni from the rest of the cast and snubbed him at the film's premiere. These developments eviscerate any inference of but-for causation relating to the events in the distant past. Lively was an independent contractor, not an employee. Title VII covers employees, not independent contractors. By its plain terms, it does not protect independent contractors. Lively, a world-famous actor who ran her own business empire and relied on lawyers to negotiate a detailed contract on her behalf of a specialized LLC for her work, plainly wasn't a standard employee. Lively was not beholden to any employer. She controlled the terms and the condition of the work she performed to an extraordinary degree. She moved the location of the film, changed the filming schedule, led meetings at her own personal residence, and demanded numerous terms and conditions without which she refused to go forward. If sexual harassment law is designed to address a power differential, her star power gave her the upper hand. She came to exercise such immense control that, put in her own words, quote, she produced every moment of this film. In determining whether an individual qualifies as an employee under Title VII, courts look to 13 non-exhaustive factors drawn from common law. California law ordinarily presumes individuals are employees, provide a different standard where, as here, there is a bona fide business-to-business contract relationship. The existence of a business-to-business relationship depends on factors that substantially overlap with the factors articulated below. Since the terms of Blakell's payment were negotiated and set out in written agreements, the common law test applies. Common law factors strongly weigh against treating Lively as an employee. Did any defendant have the right to control the manner and means by which the product is accomplished? No. Lively exercised control at every turn. The final cut of the film was her own. She reserved the right not to perform in any intimate scenes to which she did not consent. She determined the filming location and schedule, took over significant aspects of the script and editing process, as well as aspects of the musical score and costume design. She led meetings with all relevant department heads. She refused to move forward, including when presenting her list of protections, unless others acceded to the terms and conditions she opposed. Was a high level of skill required for Lively's work? Yes, Lively was an A-list actress. She touts many skills and accomplishments in her letter to the PGA. She bargained for a $1.75 million guaranteed payment, as well as an additional bonus, including a box office bonus that was required to be, quote, no less favorable than Justin Baldoni's, who was the source of instrumentalities and tools. Lively herself was the primary instrumentality of the acting work she performed, while Wayfarer and IEWUM arranged for the set and paid for ancillary materials associated with the production. Lively made decisions and exercised creative control. She claimed credit for, among other things, quote, the costume designs for all the characters, and, quote, the prop and floral designs for key film elements of the film. Who chose the location of the work? Lively told the PGA that she led the film's shift in location. She insisted shooting switched from Boston, where the film was set, to New Jersey, a location more convenient to her home. She retained pre-approval rights as to any shoots in other locations. What was the duration of the relationship between the parties, and could any defendant assign additional projects to Lively? The relationship was limited to the duration of a single project, the film. Did Lively have discretion over when or how long to work? Yes, that was an extensively negotiated aspect of the offer letter and never executed ALA. Under the financial terms, in an unexecuted ALA, Lively was also entitled to receive payment for a day she worked beyond the agreed schedule at a weekly rate of $291,667, almost $300,000. What method of payment was used? Lively's loan-out entity was paid her minimum guaranteed payment in 6 installments pursuant to the escrow agreement, with additional bonuses contingent on the film's success. What was Lively's role in hiring and paying assistants? It was extensive. Lively claimed she personally identified heads of several departments as well as freelance team members. Lively brought in a new composer and new editors for the film. She was also responsible for the firing of the first assistant director on the film. Lively's PGA letter and then it has the exhibit link, under the unexecuted ALA, Lively would have had the right to select her personal assistants, nannies, and security. Were defendants in business, and was the work part of their regular business? Yes, defendants were in the business of producing films, but it was not as if Lively walked into a pre-existing business and simply followed their rules. By her own account, she transformed the entire production process. The fact that a party was in business indicates nothing about whether plaintiff was an employee of that business. Did Lively receive employee benefits like health insurance? No. How was Lively treated for tax purposes? Not like a standard W-2 employee. As required by New Jersey law for all films shot in the state, IEWUM held a 6.37% tax from its payments to Lively's loan-out entity, but it did not withhold federal, state, or local income tax or Social Security or Medicare taxes. Moreover, the very fact that Lively now claims tens of millions in, quote, lost profits for her various companies demonstrates that she was in business for herself, not for any defendant. The fact that plaintiff was free to engage in other employment indicates that this position was that of an independent contractor. Lively cannot prove a failure to investigate claim. Lively asserts that IEWUM and Wayfarer, as employee entities, violated 2 provisions of FEHA California Code by allegedly failing to take reasonable steps to prevent or investigate harassment regarding their employees. As a preliminary matter, Lively cannot assert claims under 12940, which by its terms, as relevant here, is strictly limited to the employer-employee context. In any event, Lively's claims that defendants failed to prevent or investigate harassment would fail on the merits under either provision because she cannot establish the elements of such a claim, namely, that there was, in fact, a substantive violation. Defendants failed to take reasonable steps to prevent it, or that any such failure by defendants caused Lively any harm. First, insofar as nothing Lively experienced rose to the level of actionable harassment or retaliation, defendants had no corresponding obligation to prevent or investigate. Per regulations promulgated under, I know I said that wrong. Promulgated? There can be no standalone employer liability for failure to take reasonable steps unless the plaintiff also pleads and prevails on the underlying claim of discrimination, harassment, or retaliation. Because also she does not create a standalone tort, the employee has no cause of action for a failure to investigate unless actionable misconduct occurred. Second, undisputed facts show the defendants took, quote, all reasonable steps to prevent harassment from occurring, thereby fulfilling their statutory obligations. The reasonableness of any employer's measure depends on the context. The regulations under 12940 call for a, quote, an individualized assessment depending upon numerous factors, sometimes unique to the particular employer, as well as upon the facts of a particular case. Reasonable steps to prevent discrimination can include the establishment and promulgation of anti-discrimination policies and the implementation of effective procedures to handle discrimination-related complaints and grievances. Wayfarer took each of these measures. It had a separate HR department as well as an employee handbook with clear anti-discrimination, harassment, or retaliation policies. Pursuant to those policies, individuals who believed they had experienced harassment were invited to discuss their concerns with their immediate supervisor or any member of management or human resources. IEWM also held an anti-harassment training administered by an outside law firm during pre-production and provided call sheets with a hotline for workplace complaints. Lively may argue defendants failed to act reasonably because no formal investigation into issues she raised took place, yet Lively herself conceded it was reasonable for defendants to forego any investigation. Her lawyer offered a proposal list of protections in lieu of a, quote, more formal HR process. The legal significance of her specific request not to investigate it is that it shows defendants' alleged decision not to do so was perfectly reasonable. Third, Lively cannot prove, as she must, that any technical failure to investigate or remediate was a substantial factor in causing her purported harm. No formal investigation would have made any difference because defendants similarly acceded to Lively's requested protections and demands. Filming continued thereafter without issue or incident in what Lively described as a completely safe and professional environment. No deficiency in the remedial apparatus of Wayfarer or of IEWUM contributed to Lively's alleged harm. She claims she was injured primarily by an alleged smear campaign that took place well after Wayfarer and IEWUM were no longer responsible for supervising on-set behavior related to the film. Lively cannot prove aiding and abetting claims. Lively claims Abel, Nathan, and Tag aided and abetted harassment and retaliation in violation of FEHA. This claim for secondary liability cannot stand because there is no primary liability. For reasons stated above, no actionable harassment or retaliation occurred. The record is especially deficient as to any claim that Abel, Nathan, or Tag aided and abetted any harassment. That alleged conduct occurred during or before June 2023. Nathan's company, Tag, was not retained until August 2024, more than a year later. And there is no evidence that Abel substantially assisted or encouraged anyone to sexually harass Lively at that point either. Lively's contract claims fail. Excuse me. Lively's contract claims against IEWM and Wayfarer, the entity defendants, are based on two punitive agreements, what she calls the actor loan-out agreement and the contract writer agreement, but neither is enforceable by Lively. The ALA was expressly subject to multiple conditions precedent that were never fulfilled, and no final agreement was ever reached or signed with respect to its material terms. The CRA was, by its terms, to be incorporated into the unexecuted ALA as an amendment. It was therefore subject to the same unsatisfied conditions, precedent, and incomplete formation, and also was not independently supported by valid consideration. And even if the ALA and CRA were enforceable, Lively's claims would still fail for multiple reasons. Lively cannot enforce either alleged agreement. Lively cannot enforce the actor loan-out agreement. Any condition precedent in a contract must be performed before the promisor's duty of performance arises. Before liability can arise on a conditions expressed or implied in fact, such conditions must be. It says the draft ALA contains a California choice of law provision, but such contractual provisions do not apply to the question of whether a valid contract was formed. The choice of law question is largely irrelevant here because Lively cannot show the ALA is valid or enforceable under either New York or California law. It is disputed that the parties never executed the ALA nor agreed on its final terms, and Lively never signed the inducement, each of which was a condition precedent to IEWUM's obligations. Nor were these express conditions waived. Indeed, IEWUM's representatives flatly refused to remove these conditions precedent when Lively's counsel suggested compliance had been waived. IEWUM's behavior was a far cry from conduct, quote, so inconsistent with an intent to enforce the rights as to induce a reasonable belief that such right had been relinquished, as is required to find a waiver of a contractual right. If anything, Lively's counsel repeated attempts to remove the conditions precedent from the draft ALA is compelling evidence that Lively knew IEWUM had not waived compliance with the conditions precedent. Precedent? I'm saying that wrong, whatever. For substantially the same reasons, the draft ALA was never a binding agreement. When it is clear that both parties contemplate that acceptance of a contract's terms would be signified in writing, the failure to sign the agreement means that no binding contract is created. Here, the undisputed facts show the parties communicated an intent not to be bound absent full execution via 1. The clear condition precedent language in the draft ALA, which IEWUM refused to remove, and 2. IEWUM's continued effort to obtain Lively's signature through July 2024 and her continuing refusal to provide it as a manifestation of acceptance, and 3. The entire agreement provision of the draft ALA as well as a similar provision to the standard terms. The presence of such a merger clause is pervasive evidence that the parties did not intend to be bound prior to the execution of a written agreement. Nor do the facts establish that the draft ALA remained unexecuted simply as a matter of neglect or convenience after final terms were definitely agreed to by the parties. To the contrary, the undisputed facts establish that the parties continued to negotiate material terms until July 2024 and no final agreement was ever reached. Quote, there is no meeting of the minds of the parties while they are still negotiating terms. Even if the sexual harassment provision, the provision Lively claims was breached, remained subject to revisions when the last draft was exchanged. To the extent any binding agreement enforceable by Lively was arguably formed, in terms were those set forth in the offer letter, which was fully negotiated and agreed upon in May 2023, not in the ALA, the terms of which were never finalized. IEWUM does not dispute that. Consistent with the offer letter, it placed Lively's upfront fee into escrow and accepted Lively's services on the first phase of filming. Critically, however, the offer letter does not contain the provisions that Lively says were breached. Thus, whatever the validity of the offer letter and Lively's right to enforce it, the letter cannot salvage Lively's fatally defective breach claims, which stand outside the letter's plain text. Lively cannot enforce the contract writer agreement. Lively cannot enforce the CRA even though it was fully executed because it was expressly made part of the ALA, and Lively's right to enforce the CRA was subject to the same unsatisfied execution conditions, precedent, and incomplete formation of the agreement. The CRA was not intended as a standalone agreement independent of the ALA. Rather, by its terms, it provided, quote, additional terms and conditions in connection with the artist's services and was deemed incorporated into the ALA. Nothing in the CRA suggests its provisions could be enforced independently of the unexecuted ALA. Hold on, there's something I need. Moreover, the very existence of the CRA demonstrates that the parties were still negotiating the ALA and seeking to amend and supplement its terms. The CRA's plain text shows it was intended to be integrated as part of the final ALA, but there is more. The conduct of Lively's counsel confirms the parties' understanding that, even though the CRA was finalized first, the CRA was to be an ancillary amendment to the unfinalized, unexecuted ALA. After the CRA, which the negotiators referred to as a side letter, was finalized, the parties renewed their efforts to finalize the ALA, and Lively's counsel continued to edit the standard terms to be included therein. stating such terms which be incorporated into the underlying agreement as amended. The CRA is also unenforceable as an independent agreement because it is not supported by any valid consideration from Lively. The CRA is silent with respect to any further obligation or forbearance on her behalf. The only arguable consideration considering the CRA was Lively's promise to fulfill her pre-existing obligation under the terms of the offer letter to perform as Lily in the film, for which IEWUM had already paid Lively her full upfront fee into escrow. A promise to perform a legal obligation is not sufficient consideration for a contract based therein. The plain language of the CRA confirms that the purported consideration for the deal was, quote, to cause artists to render acting services on the picture, but that was the exact same obligation IEWM had already paid Lively to perform months earlier, and to the extent Lively re-engaged on her obligations without returning her fee, she would have been liable for breach of the offer letter at minimum for unjust enrichment. The CRA's boilerplate recitation that, quote, good and valuable consideration was exchanged is beside the point. As such recitals cannot overcome an absence of real-world consideration. Although Lively's counsel vaguely alluded in email correspondence to the possibility of foregoing a more formal HR process, when she initially proposed the 17 protections to return to production, she was explicit that Lively was not, in fact, agreeing to forego or even delay any claim, instead reserved all legal rights. Moreover, the CRA itself included no term embodying a promise that Lively would forego or delay any claim. This sort of illusionary promise, which is so insubstantial as to impose no obligation, is not valid consideration. Even if the ALA and CRA were enforceable against the entity defendants, Lively's breach claims would fail as a matter of law. The entity defendants did not engage in conduct rising to a breach. Both of Lively's breach claims turn on the contention that IEWUM, through its agents, sexually harassed Lively and then retaliated against her for raising concerns. As discussed above, Lively does not come close to establishing a genuine issue of fact to any such claim. The entity defendants The entity defendants' alleged conduct cannot constitute a breach because Lively failed to provide a notice and an opportunity to cure. Lively's breach claims also fail because she failed to provide 30 days notice and an opportunity to cure as required by the ALA's company's breach provision, which also governs the incorporated CRA. That provision states that no act or omission of company hereunder shall constitute any event of default or breach of this agreement unless artist, Lively, shall first notify company in writing setting forth such alleged breach or default of company shall not cure the same within 30 days after receipt of such notice. A notice and cure provision of a contract will serve as a bar to a notice and cure provision of a contract will serve as a bar to a claim for breach of contract, where the provision was clearly stated in the contract that was allegedly breached. Lively never provided the requisite notice and opportunity to cure before asserting her breach of contract claims. To be sure, Lively's attorneys sent a cease and desist letter on December 20th claiming that Wayfarer and others had breached the CRA. But that letter was not addressed to IEWUM as required by the contractual notice provision and did not mention any alleged breach of the ALA. In any case, Lively filed her breach claims on December 31st, only 11 days after sending the cease and desist, far less than contractually mandated 30-day period. The only relevant notice Lively delivered with aspect to the ALA was the November 2023 email in which her counsel presented IEWUM's counsel with the protections for return to production, but that email did not set forth any alleged breach as required under the ALA's notice and cure provision. It was therefore insufficient under the language of the punitive contract, and as discussed below, any arguable breach alleged in that email was cured. By its terms, the ALA and incorporated CRA provide that no breach can arise absent notice and an opportunity to cure. As such, the provision for the agreement that defines the breach is not ambiguous. The clear and explicit meaning of the provision is that a party may be held in breach of the agreement only after receiving written notice of breach from the other party and failing to cure the breach within 30 days of receiving the notice. Because there is nothing in the record showing Lively provided IEWUM with such a notice of breach, or that she accorded 30 days to cure the alleged breach as expressly required under the agreement, there was no cognizable breach by the entity defendants. Even if notice were provided via Lively's counsel, November 2023 email, the entity defendants indisputably cured any potential breach based on the alleged sexual harassment. It is undisputed that when work resumed after the writer's strike and following receipt of Lively's list of protections, there was no reoccurrence of any alleged impropriety. Work on set proceeded without issue or incident, without a single concern raised about even a single item that might give rise to a potentially hostile work environment. As a result, any source of discomfort that could arguably give rise to a claim for sexual harassment had been completely cured. The notice and cure provision underlying both the ALA and the CRA, any noticed sexual harassing conduct having been cured cannot constitute a breach. While Lively claims separately that the ALA and CRA were breached based on acts of retaliation, there was no actionable retaliation, let alone any temporal or casual nexus between the alleged retaliation or any concerns Lively had raised, in an altogether different context and at an altogether different stage many months before. Even if there was a breach by IEWUM, Wayfarer would not be liable because Lively cannot establish alter ego liability. Lively's breach claims against Wayfarer suffer from an even more obvious defect. Wayfarer was not a party to the punitive agreement and therefore cannot be liable for any breach thereof. Under California law, only a signatory to a contract may be liable for any breach. Lively's implicit contention that Wayfarer is liable for a breach as IEWUM's alter ego is unavailing, because a member of a manager of an LLC cannot be held liable for the debts, obligations, or other liabilities of the LLC, whether arising in contract, tort, or otherwise, solely by decision of his status as a member or manager. Rather, the party seeking to have the corporate entity disregarded bears the burden of proving that the alter ego theory should be applied. Alter ego is an extreme remedy and sparingly used. Courts apply that doctrine when the corporate firm is used to perpetuate a fraud, circumvent a statute, or accomplish some other wrongful or inequitable purpose. Lively cannot prove that Wayfarer should be liable as IEWUM's alter ego. First, no equitable result would follow from recognizing the corporate form. Establishing inequity requires direct evidence of specific manipulative conduct, which must include some conduct amounting to bad faith. Without something more, simply availing oneself of the protections provided by corporate charters is not misconduct sufficient to justify a court in finding a corporation to be an alter ego. There was no manipulative conduct by Wayfarer or IEWUM here. Lively was presented by a sophisticated entertainment counsel during her negotiations with IEWUM, and her counsel knew that the contractual counterparty would be a designated production service entity, not Wayfarer itself, as is customary in the film industry. Indeed, it was Lively's counsel who redlined the offered letter to substitute IEWUM as producer, whereas the initial draft had defined producer as Wayfarer Studios or its designated production service entity. Any suggestion that it was manipulative or bad faith for IEWUM to be a counterparty is also belied by Lively's own use of a loan-out program, Blakel Incorporated, as a counterparty to the alleged agreements. Second, Lively cannot establish IEWUM and Wayfarer had such a unity of interest and ownership that the separate personalities of the corporations and the members no longer exist. IEWUM maintained its own separate bank accounts and funds, had its own counsel, and independently engaged the cast and crew of the film, only a few of whom were Wayfarer employees. Although Wayfarer and its employees provided some support to IEWUM on the film, that is common in the film industry, and IEWM paid Wayfarer redacted for those services redacted. Lively's alleged damages for breach are barred by the limitations on damages provisions of the ALA and are not cognizable in any case. Even if Lively could establish a triable fact on her breach of contract claims, most, if not all, of her asserted damages were barred by the ALA's limitations on damages clause, which excludes consequential or incidental or special of or punitive damages. Although California law prohibits pre-dispute limitations on damages for willful injury to the person or property of another, that principle does not preclude parties from limiting their liability for pure breaches of contract, like those at issue here. Here, little, if any, of Lively's asserted injury consists of general damages that flow, quote, directly and necessarily from a breach of contract or that are a natural result of a breach. Rather, nearly all of Lively's asserted damages are paradigmatic, consequential, incidental, or special damages, secondary or derivative losses arising from circumstances that are particular to the contract to the parties. Lively claims, for instance, the defendant's conduct caused associated businesses to suffer millions of dollars in, quote, lost profits. She also claims tens of millions more in lost profits, which Lively refers to as lost earnings, from the speculative loss of entertainment deals with third parties. Lively also claims tens of millions from reputational harm, which appears to be a simply double counting of her alleged future lost profits. None of these damages flow directly or necessarily from the entity's defendant's alleged breaches. They are instead secondary or derivative losses based on Lively's particular circumstances, namely her expectation of obtaining income from her affiliated businesses and subsequent entertainment-related contracts with third parties. Under California law, lost profits can constitute direct damages only where the profits lost were due under the breached contract itself, not future or unidentified contracts. The footnote: moreover, the limitation on liability in the ALA should not be treated as pre-dispute because it remained in the draft agreement after Lively raised the concerns resulting in the execution of the CRA, and the parties subsequently continued to negotiate terms. Lively does not contest that any of her lost profits are monies owed by the defendants under the contract. Thus, the lost profit Lively seeks are best categorized as consequential, not general damages, are expressly barred by the ALA. Thus, Lively's lost profits, lost wages, and reputational harm are all consequential, incidental, or special damages and barred under the limitations on damages provision. Lively's only alleged damages that do not fall in the bucket of consequential, special, incidental, punitive damages are her alleged pain and suffering, physical pain, and humiliation. It is unclear whether Lively contends these are proper damages for her breach claims as opposed to her tort claims. To the extent she does, her contention is barred because such damages are not available for breach of contract. The invariable rule is pronounced by a legion of cases that damages are not recoverable for mental suffering or injury to reputation resulting from a breach of contract. Thus, it has failed to satisfy damages, which is a necessary element for a breach of contract. Lively's contract claims are improperly duplicative. Even if Lively's contract claims had merit, they would be subject to dismissal because they merely duplicate her harassment and retaliation claims. Tort claims generally are not duplicative of contract claims because tort claims offer a separate measure of recovery. However, a claim is duplicative if it seeks the same damages or relief already sought by another claim. Here, however, Lively's theory of damages for her contract claims and her statutory tort claims are entirely overlapping. Lively is not entitled to double recovery for the same injury by pleading both tort and breach of contract claims. Because she cannot establish any independent damages for the alleged breach, her contract claims would be dismissed, or should be dismissed. The defamation and false light claims fail. New York law applies to Lively's defamation and false light claims. A federal court sitting in diversity or adjudicating state law claims that are pendant to a federal claim must apply the choice of law rules of the forum state. Under New York choice of law rules, the first step is to determine whether there is an actual conflict between the rules of the relevant jurisdictions. Here, there are conflicts. New York does not recognize a cause of action for false light invasion of privacy. New York and California defamation laws, while similar, also conflict in certain respects. In tort cases, New York applies the law of the state with the most sufficient interest in the litigation. In a multi-state defamation case, the plaintiff's domicile will usually have the most significant relationship to the case, and its law will therefore govern. This is a presumptive rule, which is overcome only if some other state has more significant relationship after taking into account where the plaintiff suffered the greatest injury, where the statements emanated and were broadcast, where the activities to which the alleged defamatory statements refer took place, and the policy interests of the states whose law might apply. All factors support application of New York law. Firstly, Lively resides in New York, and as New York recognizes a plaintiff's home state as where the plaintiff's reputation is most likely damaged. This is true even where the complained statements are published multi-state. While Lively complains about statements heard, viewed, or read millions of times around the world, the claim she complains of is personal harm in New York, including to her reputation in the community as well as grief and anxiety. Lively also filed a suit in New York, Kensley versus the New York Times, based on allegations that all defendants transact and solicit business within the state, have committed the torturous act described in the complaint within the state, and have committed such acts outside of the state causing injury to plaintiff within the state. Second, the complained of statements largely emanated from New York. Lively's allegations are largely based on statements disseminated through publications and other media outlets headquartered or based in New York, including the New York Post, the New York Times, USA Today, People Magazine, Page Six, and The Megyn Kelly Show. New York has a strong interest establishing defamation standards for media outlets domiciled in the state. Third, the alleged defamatory statements refer to activities in New York and its environs. Lively alleges defendants launched a coordinated campaign to cast her in a false light during the publicity and promotion of the film and thereafter, and points to statements related to conduct on set. The film was primarily shot in New Jersey, and the premiere and some of the production took place in New York. Many of the statements concern responses to the New York Times article about the dispute or the allegations filed in this court. The only relation to California is the general involvement of Hollywood's entertainment industry and the fact that 2 uneventful days of shooting took place there after Lively's concerns were resolved. That certain, but not all, defendants' residence there, and that Lively filed an administrative complaint there after the fact. The fact pattern favors New York to a greater degree here than in Kenzie, where the underlying events had no connection to New York whatsoever. Finally, New York clearly has an interest in prioritizing its citizens, like Lively, from defamatory conduct, an interest not outweighed by other states. Lively's false light claim fails. The false light claim cannot proceed because New York law applies and New York does not recognize the tort of false light invasion of privacy. Summary judgment on that claim must be entered for the defendants. Lively has no standing to bring a false light claim. Even if California law applies, Lively still lacks standing. The false light claim arises from Article 1 of the California Constitution, but the California Constitution expressly grants Californians a right of privacy and does not apply to Lively, who resides in New York. Because Lively is not a California resident, she may not bring an invasion of privacy claim under the California Constitution. Lively's defamation claim fails as a matter of law. Nor can Lively establish a triable issue for her defamation claim. Lively generally contends that Wayfarer, Baldoni, and Heath, through their agents, published false statements asserting that Lively's allegations of harassment filed with the California CRD and this court were false and fabricated. That is, Lively's defamation claim is, by definition, based entirely on statements about the litigation published after litigation commenced. This claim fails for multiple reasons. Lively cannot prove falsity or malice. Lively's defamation claim fails because it is premised on the conceit that her harassment and retaliation allegations are true and any contrary statements false. But as explained above, superpoints 1 and 2, Lively's claims and allegations do not rise to the level of harassment, and no retaliation for complaints or harassment occurred. It is axiomatic that truth is an absolute unqualified defense to civil defamation action, and that any substantial truth, that is all that is required. The defamation defendant's statements denying the truth of Lively's allegations and asserting, for example, that the claims are completely false, were true, or at minimum, substantially true. Lively's claim therefore fails as a matter of law. Just as significantly, defendants' alleged statements denying the truth and validity of Lively's claims and allegations were not statements of objective fact and therefore cannot constitute defamation as a matter of law. The Second Circuit confirmed just last week that whether conduct arises to the level of harassment and what is meant by the term is often a subjective inquiry that permits differing opinions among those involved in or aware of the alleged conduct. Any ultimate conclusions about whether conduct amounted to sexual harassment or retaliation is a subjective one or a legal one, and statements expressing such conclusions therefore cannot, without more, constitute actionable defamation under New York law. Premise: definitive meaning, such as statements denying the existence of such a campaign, reflect constitutionally protected opinion. Likewise, assertions that, for example, Lively was, quote, pushing her own self-serving and selfish vendetta, and her claims were outrageous and intentionally salacious, are likewise precisely the sort of an opinion statement that cannot be objectively proven and is therefore not an actionable basis for a defamation suit. For substantially the same reasons, Lively cannot prove the requisite malice. As a public figure, for purposes of the First Amendment analysis, Lively must demonstrate with clear and convincing evidence that the defendants realized that their statements were false and that they subjectively entertained serious doubt as to the truth of their statement. Lively contends that the defamation defendants knew her allegations were accurate because they signed the CRA and knew that Ms. Lively was not alone. The CRA was not, by its terms, an acknowledgement of any past conduct. It was expressly forward-looking. But even accepting Lively's spin on the document, it shows at most the defendants knew complaints were raised, not the complaints were true. The alleged defamatory statements were absolutely privileged. Lively's defamation claim also fails because it is based on statements that were absolutely privileged under New York law. New York's fair of report privilege protects any fair and true report of any judicial proceeding, legislative proceeding, or other official proceeding. New York courts adopt a liberal interpretation of the fair and true report standard so as to provide broad protection to news accounts of judicial proceedings. Here, the post-litigation statements Lively claims were defamatory all merely repeat allegations defendants had already asserted or would soon assert in the action, namely that Lively's allegations of harassment and retaliation were false and self-serving and could not constitute actionable claims. And then it has a compare, and then I think it's like an exhibit number. It is shameful that Ms. Lively and her representatives would make such serious and categorically false accusations, with defendants describing Lively's troubling pattern of manipulation and lies. The fair report privilege applies to a party who communicates as a complaint to the press before the complaint is publicly filed. Moreover, permitting a defamation claim to proceed to trial based on an attorney's blanket denial of serial accusations against his client would raise serious First Amendment concerns. For that reason and others, New York courts have extended the fair report privilege to comments made by attorneys to the press in connection with the representation of their clients. Here, the alleged defamatory publications all essentially summarize or restate the defendant's litigation position as expressed in their filings and are thus privileged. And then the footnote says, one of the statements Lively's claims is defamatory appears verbatim in defendant's complaint. Lively's conspiracy claims fail. We're on page 69 of 73. We're almost done. Lively's conspiracy claims fails for several independent reasons. First, there can be no claim of conspiracy where, as here, there is no actionable underlying tort. Second, even if Lively had a variable tort claim, her conspiracy claims would be entirely duplicative of it and should be dismissed on that ground as well. Third, outside of tort liability, no claim for conspiracy will lie. A breach of contract may not serve as the basis for a civil conspiracy claim, nor does New York civil conspiracy law extend to Lively's federal and state statutory claims. There is no basis for liability against defendants Sarowitz. Lively alleges only two claims against Sarowitz, false light and conspiracy. For the reasons discussed, these claims fail. Even if these claims could proceed against any defendant, no reasonable jury could find Sarowitz liable. His exceptionally limited involvement confirms why, and the record is devoid of any facts implicating him in either claim. Sarowitz is the majority investor in Wayfarer Studios and provides the studio with financing. He played no role in the production or marketing strategy of the film, visited the set only twice, and played no role overseeing press concerning the film or this dispute. Lively's claims against him are predicated on overblown comments that were taken out of context. For example, Lively alleges Sarowitz stated that he would, quote, spend $100 million to ruin Lively and her family, but the discovery record confirmed Sarowitz did not make any such comment and at all times was focused only on defending himself in the studio. Lively also quotes a surreptitious recording of Sarowitz in which he states, "There will be 2 dead bodies when I'm done." But as this recording makes clear, Sarowitz was speaking only in metaphorical terms. Left out of Lively's allegations and Sarowitz's immediate clarification that he meant not dead, but "you're dead to me." Sarowitz was focused solely on making sure the studio was protected from Lively's attacks and not attacking Lively, and he disclaimed any intent to harm Lively as not the world I want to live in. Such comments, without any evidence of any specific follow-up conduct, are insufficient to support any of the claims in which Sarowitz is named. Several aspects of Lively's damages claims must be dismissed. Lively lacks standing to assert claims for lost profits or royalties. Lively claims tens of millions of lost profits associated with 2 non-parties, Blake Brown Beauty and Betty B Holdings LLC, as well as royalties flowing from those entities. Lively is merely an indirect shareholder of these entities and not the direct beneficiary of any royalties flowing therefrom. As such, she has no basis to any claims and any such damages or to recover losses allegedly suffered by these entities. A shareholder cannot sue her individual capacity to redress wrongs inflicted upon a corporation in which she holds stock. Courts routinely reject claims like Lively's in which individuals seek redress for corporate damages, including lost profits. Lively and the business she works for are not interchangeable. An individual lacks standing to sue when the alleged injury is based on an injury to a corporate entity. Lively does not even have a direct ownership interest in either Blake Brown Beauty, which is just a brand and not a standalone entity, or in that brand's parent company, Family Hive LLC or Betty B Holdings LLC. Her purported interest in those entities exists through her interest in another non-party, LOL. Any royalty payments similarly go to non-profit party LOL HATA LLC, not to Lively. Lively cannot recover speculative lost profits. Even if Lively had standing to seek damages on behalf of these distinct corporate entities, she does not. The court should still reject her demand for lost profits. Lost profit damages are too speculative, whereas here they arise from an entirely new business venture without any proven record or financial performance. Damages for lost profits must be provided with reasonable certainty. They may not be merely speculative, possible, or imaginary. In the case of new business ventures, evidence or lost profits receives greater scrutiny because there is no track record upon which to base an estimate. Not surprisingly, courts routinely have rejected lost profit claims asserted with respect to unproven business. That is because with any business, quote, there does not exist a reasonable basis of experience upon which to estimate lost profits with the requisite degree of reasonable certainty. Blake Brown Beauty launched just days before the film's premiere. As such, there is no basis upon which its lost profits can be calculated with reasonable certainty. Both New York courts and courts in the Second Circuit have dismissed claims for lost profits where the pleadings suggest that an award of lost profits would require an unreasonable level of speculation. And although Betty B Holdings was formed in 2021, Lively claims losses only in connection with the entity's Betty Boo's brand, which launched in 2023. Conclusion. For the foregoing reasons and those stated in the defendant's motion for judgment on the pleadings, the court should grant summary judgment in the Wayfarer party's favor of Lively's claims. And that is the end of the motion for summary judgment. Thank you so much for being here and listening to me read that entire thing. Oh my gosh. If I was a judge and I read that, it would be a pretty cut and dry decision for me. It doesn't meet the level of sexual harassment by the law, and it doesn't meet the level of retaliation. So, plain, cut, motion granted, summary judgment done, no jury, no trial, everything's over. I think that's what should happen, but as we have seen many times in this case, we have no idea what the legal system is going to do. What a wild, wild ride. Thank you for that. If you want to hear me read Blake Lively's PGA letter, you can go and I will link that here at the bottom. It'll just come up on the screen and you can listen to that as well. Thank you so much for being here and listening to me read you another long-winded legal document. Make sure you're following, subscribe, and join as a member, grab some merch, do all the things that you do to support all of the other content creators that are making content about any of this. You all love me reading these things to you because I can break them down and say them in a way that you actually understand. I try not to let my personal biases come into this situation. I've always disliked Blake Lively, and this lawsuit made me understand why I dislike her. Why I dislike her. I don't know Justin Maldoni from fucking Tom, Dick, or Harry. I don't know him from anybody else. But what I do see after reading all of the lawsuits, all of the documents, is that this should have never gotten this far, and Blake Lively should have never brought this to the court. She is wasting the taxpayers' money, she's wasting the court's time, and she should just move on and kept doing something else. Let me know your thoughts in the comments and what you think is going to happen if this summary judgment gets ruled on by the time this gets uploaded, which I highly doubt it will. Maybe we will have a new break in the case. Thanks so much for listening, and I will see you on the next one. Bye!